Defendant Treon Properties, LLC.
Good morning, Your Honor. Kevin Nelson on behalf of the defendants, counterclaimants.
All right. Well, welcome to all. I know from talking with Judge Warner that the settlement conference was not successful, which I was sorry to hear, but I know that means we do need to reset, or I'm guessing that means we need to reset the evidentiary hearing. Is that correct?
That's correct, Your Honor.
Can you tell me when, I don't know if you're prepared to go right away or if you need some time to get anything more done in preparation for the hearing. Can you tell me what time frame you were looking to have it reset?
Yes, Your Honor. We held off on depositions at least until we saw whether there was success at the settlement conference. So we need to conduct those. We just got some dates from counsel. So we would ask for something not less than 60 days out or early to mid November for a hearing.
That's doable. So you tell me, I could get you in. I could get you in on the 10th or the 12th. Would either of those work? November 10th or November 12th?
They would work for plaintiff, Your Honor, yes.
They work for the defendants as well, Your Honor. Actually, they work for me. I need to check with my client, but I don't anticipate it'll be a problem. I'm sure Rob or Mr. Colley's in the same boat.
Yes.
And do you have a preference of which one of those? I don't.
I do not, Your Honor.
One's a Tuesday, one's a Thursday.
Your Honor, I prefer Thursday if we can.
All right, that's fine. We'll do Thursday, November 12th to reset the evidentiary hearing. And that will be one day, is what we set before. Is that still what you're looking to have set?
Yes, Your Honor.
Yes, Your Honor.
And so we will go from 9:30 to 4:30. And the time will be, I equally divided on both sides of the V. So what that amounts to is about 2.5 hours once you factor in breaks and lunch. And we can push it a little if anybody needs a little extra time. So I'll issue the minute entry. It'll be the same as what was previously entered. So I encourage the parties. I'm sort of on the fence as to whether or not the exchanging direct testimony by declaration actually works, because my experience since I rotate on the commercial calendar is even when people exchange declarations, direct testimony by declaration, they still want to call the same witness to give direct, although it does save some time if you don't cover all the same ground. So I will still keep that as an option, but will just remind you that you don't end up saving time if you're still going to put that witness on to testify on direct. And sometimes I understand that you may just want to have that testimony presented live. So I'll leave that at your option. You don't have to exchange direct testimony by direct, but it can be a big time saver if you're willing to just start the witness at cross-examination. They still do have to be there to testify live or virtually, which is also something that we can easily accommodate. For you, Mr. Nelson, if you have, I'll just say, get back to us within a week if for some reason your client does have a conflict. And of course, I think we probably already talked about the fact that it's very easy for us to accommodate virtual witnesses. If you have any witnesses who need to testify virtually, just make sure that you have let one another know who you would like to call to testify virtually. Make sure they have a working webcam, high-speed internet, and are in a quiet, appropriate location without any third-party or noise interference. And it has never been a problem to accommodate those requests. So there will be a new deadline for your joint pre-hearing statement. I do encourage memos if there are, now obviously you've briefed the issues on an application like this, but if there's anything you want to add in a written memo to help me prepare going in, I am fine with you doing that separately from your joint pre-hearing statement, which is really just a way for me to get you to sit down and make sure you're not giving me duplicate exhibits, and that if there is any issue with an objection or a witness that you can let me know about it ahead of time. But if you want to do trial memos in addition to that, you're welcome to. Otherwise, I will see you back on November 12th. I assume based on what you've told me this morning that you're working out any expedited discovery you need to get done. I always just like to remind parties that because your hearing is set so close in time to now, if you have a discovery dispute that you need me to weigh in on, don't hesitate to bring it to my attention sooner rather than later. That's not an excuse not to engage in a good faith consultation. But because of how quickly you're getting ready, I want to be able to get you on the line right away if there's something that you can't resolve in between now and the time of the hearing. Okay?
Yes, Your Honor. We have one or two small additional logistical issues to raise to Your Honor at the appropriate time.
Now is fine.
Okay, great. There's been a number of changed circumstances and facts since the last time we were together and since the filing of the initial pleadings. 9 of the 10 buildings have been demolished. So we are going to supplement our complaint, not amend it, but supplement it. We would ask through oral motion right now for leave to supplement our complaint so we don't have to go through motion practice in accordance with Rule 15D to address these new events.
Okay. Have you all conferred about this?
No, Your Honor, we haven't. We take issue with it based on futility. We can brief it very quickly, but there's a case that was issued in 2026 February. In fact, I believe it's called Ichthunheimer versus Val Vista Lakes. And essentially what it says, in my reading of it, is that unless a homeowner or owner in a common interest community has more than 25% of the vote collectively, they can't bring a derivative claim against the association in regard to common elements. So really, I think it resolves the issues pending before the court right now, as well as anything that would be raised going forward. If it's a complaint about the common elements, it's a personal claim by the plaintiff, that's a different issue. What I'm trying to get at, Your Honor, is that we'd like to brief the issue so that we can get that in front of the court.
And so here's my thought is I can't just grant leave under Rule 15 unless it's by stipulation without giving Mr. Nelson an opportunity to be heard on the issue and me an opportunity to see what the proposed, I know you're calling it a supplemental pleading, however it is, it really is an amendment, right? Because it's changing the nature of the allegations in light of changed circumstances, I think. But either way, whether it's a supplement or a proposed amendment, I've got to see it and I've got to give Mr. Nelson an opportunity to respond. But we can set an expedited briefing schedule on it so that we're not pushing it out as far as it normally would under Rule 7.1 timing. So if we, why don't we do that? Set an expedited briefing for you to file a motion under Rule 15 with a proposed either supplemental or amended pleading, and then we'll set an expedited schedule that we'll stick to, and I will expedite my ruling on it without oral argument. So how soon could you get a Rule 15 motion to me, Mr. Connolly?
I believe next week, certainly by the end of next week, approximately, or early to mid next week. Give us 7 days.
Okay. So today is I can't believe we're almost into September already. All right. So that would be September 2nd.
Sounds good.
All right, so it is ordered that plaintiff shall file a Rule 15 motion to amend or to file a supplemental pleading with an attached red line supplemental pleading as required by Rule 15 on or before September 2nd, 2026. And then how soon after that, Mr. Nelson, can you get a response filed?
I would anticipate within a week, so by September 9th.
Okay. And so I'll set the response date at September 9th. If you get the response by September 9th, can you get me a reply by that Friday or the following Monday, the 14th?
We can, Your Honor, yes.
Okay, so it is ordered that an expedited response to the Rule 15 motion shall be filed on or before September 9th, 2026. A reply shall be filed no later than September 14th, 2026, and the court will expedite its ruling on the motion once briefing is complete on that expedited schedule without further oral argument. All right, so that I think covers that, and that way I will tell you that, yeah, no, I can get something out to you if I get it by the 14th. The only thing I'll ask and include in my order is that at the time you file, since these are expedited, please email a copy of what you filed to both my division and to opposing counsel at the time of filing, just to make sure that we receive it right away instead of having to wait for it to be docketed through the clerk's office. And that'll just make sure my staff can get it in front of me more quickly. Are there any other motions that or issues? I thought, Mr. Connolly, you said there may be.
Yes, just a very small housekeeping matters. I know today's the last day on the court's dismissal calendar for the matter, so.
You know what? I didn't realize this was on the dismissal calendar. Alyssa, let's just include a minute entry removing this case from the dismissal calendar in light of the parties. Our status today is that they are moving forward with the litigation. So I'll remove that.
Thank you, Your Honor. That's nothing further from plaintiff.
Nothing from defendant, Your Honor. Thank you.
All right. Well, thank you, everyone. As I said, I'm here if anything comes up in between now and otherwise I'll see you on November 12th. Have a nice day. We're off the record.